Good morning and welcome to Web3 Wednesdays, where we chat through some of the complex and nuanced topics in crypto and Web3 at large so that you can stay ahead of the curve. So today I am joined by Louis Cohen of DLX Law, one of the foremost dedicated crypto law firms working tirelessly to further sensible regulation and coherent understanding of finance on the blockchain. Most recently, Louis has been involved around the theoretical support of Ripple's case against the SEC, and he was the lead author on an extensive argument against the classification of tokens as securities, entitled The Ineluctable Modality of Securities Law, Why Fungible Crypto Assets Are Not Securities. And I love that title, Louis. We're going to talk about that here in a second. Louis's position here at the cutting edge of regulatory considerations makes him a fantastic resource for builders and investors looking to understand the direction that the industry takes from here. And we're keen to hear his take on the long and short of the crypto game. So, Louis, welcome to the show.
Hey, thank you, Sam. Glad to be here.
All right. And so, Louis, just really briefly for the viewers, right? Can you describe what all you tackle in your day-to-day life in crypto law?
Sure. Well, I'm super excited to say we're coming up on our 5th anniversary of our firm, DLX Law. So that's really exciting. We really are proud of having a range of clients. We represent some projects, kind of what you would expect, startups, single person, teams, et cetera. Often they are involving tokens, but not always. They may be other things. But then we represent market participants of various types, venture investors, more traditional investors, some large scale investors who are looking to get into crypto, and then some corporates and others that are kind of intrigued by Web3. We do some Web3 gaming. I know we'll talk a little bit about that, and we cover a lot of stuff. We also represent financial institutions and others. We were proud to set up the first Wyoming-based special purpose depository institution for Kraken, and we continue to work actively in that space as well. So we cover a broad scope. We don't do litigation. We don't do sort of dispute resolution type stuff. That's probably the single biggest thing. We don't do fund formation. So there's special fund counsel if you're looking to set up an investment fund, or these days, unfortunately, a distressed investment fund. But that's not our thing. But otherwise, most stuff in the space.
That makes sense. Let's even kind of dig into the legal problems in the space right now. So the big question is always securities. It's across the board. Securities come to mind. And so, what is a security, and why should people even care about that definition in the first place?
Yeah, it's a great question, and really perhaps the most important question. I think folks sometimes get tangled up between fundraising transactions that sort of use unusual means, which is really what this Howey test is designed to get at. If when people give money to other folks to sort of effectively deploy, invest, create profit. As a policy matter, we believe that's a special relationship, and there's special guardrails that should apply to that. And interest in those investments also should be protected. That's our concept of securities. Rather than just enumerating stocks and bonds and things like that everybody understands, Congress, I think very wisely, threw in this catch-all category that's caused all this challenge, the idea of an investment contract. The idea here is you can't put old wine in new bottles and sell it to people. If you come up with a new name for something, but your activity is all the same, then that activity should be regulated. So things like ICOs gave a different name, but they're basically fundraising transactions where people put money in and had a direct relationship with the people they were giving the money to and sought to make a profit in due course. So that's the gist of the Howey test. The mix-up, or I think the area of confusion, is the Howey test has never been extended to the asset or whatever was being sold itself. And in particular, where those assets trade in secondary markets, there's really no current basis in law for saying those assets are themselves securities. People argue, well, maybe there are other sort of investment contract transactions, have all kinds of theories, but they're really differentiated. So I think what our paper seeks to do on a broad level is trying to sort out securities are important because we want to protect people who are investing money. People are buying assets that are not securities, in general, transactions. So, for example, if you and I were sitting down and trading, I sold some uni to you, or you sold some ADA to me, those should not be, in my judgment, under current law, considered securities transactions.
That makes sense. And it's a powerful and important stance to take because obviously, everyone who's using DeFi makes those kinds of transactions on a daily basis, right? And so everything that, is classified as DeFi would fall under that jurisdiction. And this is kind of a good, segue into, your draft and your piece itself here. And I'll let you talk through the title here in a second. It would be kind of unfair, right, to ask me to have you, summarize the entire piece in a couple of sentences. But, can you at least break down the title? What can people expect from reading your guys', recent massive drop here?
Sure. The title is definitely a bit of a tongue twister. I don't dispute that. I'll take the title and then how it kind of fits into things. The ineluctable is a term that means sort of inescapable or inevitable. And modality, of course, is just the way of something, the nature of something, its inherent nature. So what we're trying to say is we're talking about securities law. We're saying what's the inherent nature of securities law? What is really the core element of securities? And basically what we say, it's a legal relationship between somebody who is providing capital and somebody who is receiving the capital, whether it's equity or debt. It's that relationship. That's the ineluctable nature of security. So that's broadly what we want to say. There's another sort of level of the meaning which we really like. I'm a big fan of James Joyce's Ulysses, and for I don't know, everybody's cottoned on to this. The ineluctable modality of the visible are the first lines of chapter 3 of Ulysses,
which is very cool, Lewis.
Yeah, which is generally the chapter that Joyce loses people because it's really it's a difficult chapter, but the chapter is all about change. Joyce named that chapter Proteus. Each of the chapters has a Homeric name, and Proteus is sort of this god of change and changeability. The quote at the beginning is from Homer, and it's this idea of morphing and changing from one shape to another shape to another shape. Our point is that's not securities. Securities don't morph from one thing to another. They don't change. They have an inherent nature, and that's what it is. And I think that's what we need to focus on. So that's sort of a little bit of decoding the title and really the important idea. The fundamental thesis of that's been put forward by the SEC, which I do disagree with, is that the nature of a token, its security status, can change depending on the circumstances. And I think when third parties, you and me, for example, vis-a-vis an ADA token, we have no way of knowing what those circumstances are, and the law is not designed as a gotcha. Speaking of which, it's not a gotcha kind of situation where you can't know whether you're dealing with a security or not. That's just very contrary to our principles of laws. And in our paper, we cite cases and a lot of support for that position.
No, and Lewis, the entire description there from title to bottom is fantastically nerdy and digs in on exactly the problems that we need to discuss in space right now. So I love it. Even, kind of going one step deeper here, right, and generalizing a little bit for the listeners so that we make sure that everyone's on the same page. So if crypto assets are not securities, all right, can you walk us through the classification system that you would use to define them instead, and any, interesting exceptions around those rules?
Sure. Firstly, to state the obvious, we talk about most tokens. There's certainly there are a couple of exceptions. First and foremost are things that want to be securities, right? That people are trying to create securities. A good example of that is the Gibraltar-based exchange INX created a token. They actually registered with the SEC. They called it a security. It was never not going to be a security. It's just a security, also a token. Wonderful, great. And there are other people, particularly in other means, have created security tokens in that the security is meant to, in some way or another, the token is meant to, in some way or another, represent or at least be a critical part of that security. So we don't cover that because, hey, look, everybody's saying, I want to create a security. The second thing that's more tricky and probably a bit more relevant to some in your audience are unusual sort of sets of circumstances. DAOs in particular can be tricky if what you're doing with your token is creating something that looks like a business venture, and your interest in the business venture is the token, where there's some active participation by all the parties. Then you get into a question, well, what exactly is the relationship of the parties amongst each other? We saw this with Oki DAO a bit. They characterized Oki as an unincorporated association. A partnership is basically a variation of that. What is that nature? You could have a situation where there are dominant people in a relationship like that, and you actually conclude that most of the non-dominant people are effectively investors in a scheme being actively run by the dominant people. where there is centralization. So those circumstances can occur. So I think people have to be careful and think through and talk to experienced lawyers about, what exactly are you doing and how you're doing it. So those are a couple of potential, exceptions that are people should keep an eye out for.
Yeah, I think that makes a lot of sense. And, kind of digging in deeper on that, one argument against some of these securities definitions is this idea of decentralization, which you kind of touched on right there, right? Where you have certain elements, certain contenders within the space who are participating to some degree. Maybe it's not enough of a degree, right? This decentralization argument in and of itself, do you see that as a proper defense of these projects to the question of, are you a security? What level of decentralization is actually appropriate for a defense like that to even work?
Well, the question really, for me, the starting point is, is the token seeking to create some sort of relationship that's a legal or economic relationship, so that you've got, kind of a group there with tokens like, layer one tokens, which are easy examples. There's no relationship. You don't have a relationship with the Cardano Foundation or the Ethereum Foundation or whichever thing or anyone else. You're just using a piece of technology. DAOs can change that depending on how they're structured and set up. Sufficient decentralization, I think, can be a relevant factor in the latter case, in situations where you have a group of people working together. Our securities laws have contemplated for a long time the idea of an investment club. Let's forget crypto for a moment. We just have a bunch of buddies and friends, and we're all going to get together. We're going to pool some money, and we're going to buy stuff, stocks or bonds, or make other investments. Maybe it's real estate, what have you. We're all working together as a group. We're all pooling our ideas. You're better at valuation. I'm better maybe looking at the legal structure, but we're all kind of jointly involved. Generally speaking, those sort of arrangements are not securities arrangements. You could call that sufficiently decentralized simply because there's not a dominant person sort of leading that. But if we're doing a business venture and really I'm just along for the ride, and man, that Sam guy, he knows what he's doing, I'm just kind of counting on him to make great decisions, you're now changing the matrix a bit. Whether the venture is technology or real estate, it doesn't really matter. When you have a group of people and some are really predominantly relying on others, you have a different arrangement. I just want to emphasize that's where the token you have purports to, in some way or another, represent an interest in the business as opposed to just a technology that you use. That is a very, very foundational difference and can't be overlooked.
Yeah, and that's actually that difference is exactly where I wanted to go next. Even the tokens, there's a huge amount of variance in the governance and the legal structures and even the engineering that go into these things, right? So just to take one very discrete example, you have certain tokens that claim to be governance tokens, but you can't actually govern anything on chain. You can effectively place a Facebook poll and tell a manager what to do, and you hope that they do it. Then there are other tokens, right, where you can govern on chain, and your vote is required, or hopefully needed in some capacity to execute some on-chain transaction, in which case you're directly managing, the venture or the project yourself, right? Those are two very different governance structures that I think get mixed up quite a lot in the nuance here, and people, don't quite capture the difference. From a legal perspective, is there a difference? And is there something that projects should be, potentially either looking to build for or looking to not build, within those two frameworks?
Yeah, it's a great question. A case involving real estate, a lot of these cases from the past obviously don't involve tokens because we haven't gotten that far down the path, but called Williamson v. Tucker. And there, it was not a Supreme Court case, but a very well-regarded circuit court kind of in between case there. And they looked at three factors. And I think you can't sort of boil it down to just one. Do all the people have the sophistication to make the decision? So, you can have something that's very, very technologically oriented. Someone has a governance vote. It could be an on-chain or off-chain, but they have no idea, what is involved. They have no computer science background whatsoever. They haven't the vaguest idea their elbow from the place they sit on. That's a concern. A second concern would be they're sophisticated, but they don't have access to the information that's necessary. Now, many DAOs do a pretty good job of this, but sometimes they can fall down in that regard. Are there private conversations? Are decisions being made, in sort of small groups, and then something kind of fully launched and then thrown out there, yay or nay? That, again, is going to be problematic. All the participants may be sophisticated, but they're not really given the opportunity to engage in the process. So that's, another concern. And then also, the people may have the sophistication, they may have the access, but they don't always have the practical ability. So for example, if somebody holds, just in the most obvious case, 80% of all the votes, and you hold 20% of all the votes, and you only need a simple majority, you could have access to all the information you want and be as sophisticated as you want. It doesn't make any difference, right? So it's not quite as simple as on-chain or off-chain, but you really have to look at the underlying dynamics to figure out, kind of what's going on. My concern really around DAOs, I've said this often, is what I like to call the Netflix problem. So it's 9:30 at night, you finished your work, you put the kids to sleep, you kind of say, right? You got, your partner's there, and you got two choices, right? You can log in and start looking at governance proposals for some DAO you're a member of, or you can watch Netflix. Are you motivated by this DAO? Are you engaged enough to say, actually, I'm going to dedicate a couple hours of my time tonight after I've dealt with everything else to really think about and engage? There are projects like that, and they're very sticky projects. They're projects where people are very engaged and they want to do that. That's wonderful. I think where it becomes more financialized, look, I hope this project works out. I'm supporting my buddy Sam. I can't be bothered. I'll vote. I'm going to read this shit. Forget my French there. Sorry. But, right. So I think you have to look at this stuff practically in order to figure out what's going on. So that's kind of my thought on it.
That's a really interesting framing. And if you don't mind, I'm going to use that Netflix problem because I quite like that.
There are no copyrights involved. Open source.
No, I think that's great. And it gets to this kind of tragedy of the commons situation, right? Where you have the best intentions for the people, but it's hard to convince people who are marginal holders in these projects to actually go out of their way to dedicate time that may be in excess of whatever opportunity cost they've assigned to their holdings in the project in the first place, right? And so it's natural for them to opt out, which is a problem for governance. I also really like that you framed this idea of the sophistication of the participants really matters, right? And I think that's very fair. So it does matter that your participants are both well-informed, they have access to the information, they can make the decisions, they understand the process. And if those are true, then, potentially they are participants in the operations themselves. But yeah, if you just have a Tesla shareholder, they're not going to be designing the engineering of, the individual cars, and that's more of a financialized situation.
Can I give you one just example on that? Because a lot of the DAOs obviously emerged out of governance of complex computer protocols, and were really best suited for devs and people who really understood that stuff. But as the DAO community moved on, we saw a bunch of other ideas. Some that I would say fall on the other end of the spectrum are DAOs around kind of creative. So there's stuff about like writing a novel or creating stories, things like that regular folks can, if you're creative, you can contribute to. So I think there are a lot of possibilities. I think also I would like to see the DAO community sort of slow down a little and get back to basics. There are areas where I think DAOs are a natural fit, things where there are financial interests and strong stickiness. A religious community, for example, they have a treasury, they need to decide how to do things. They're kind of disparate, but they can do things. A housing association, there are places where there's stickiness, a school or other, so there are places where you have a treasury, you need to allocate funds, you want to do it on a communal basis. Not everybody has time to get in a room together and have a town hall. Okay, what are we going to do? So DAOs can work really well in a lot of different settings. I think thinking of it as a cure-all for all business arrangements, I think that's tough. I'm not saying that it can't be creatively applied, but I just want to give some I think, potentially very workable ideas.
No, I love that. Those are good real world applications. I actually really like the religious example. They are already quite decentralized. I mean, that would be very interesting to see, a smaller group actually adopt that. And I think, even kind of looking into the space right now as it's framed for, both investors as well as builders, a lot of the concern is on the retail players. It's not so much on the VCs or the institutionals, right? They are sophisticated enough to know what they're playing with. But today's regulatory framework, it doesn't appropriately capture and frame a lot of the risks that are inherent to the Web3 and the digital asset space to both, builders and retail investors themselves. And it's a problem. It's a problem for investors because you may end up with projects that get into a lot of trouble. Problem for retail investors, obviously, because they may be buying what they don't understand. It's a problem for builders because they don't know what the bounds are, right? And so, as we kind of think about what's missing from today's regulatory frameworks, what would you point to as some of the things that, we should really be paying attention to and maybe even trying to push forward for sensible regulation here in the space?
Yeah, thank you. I mean, there are two real areas that I think the law can and should be enhanced. The first is transparency. Even where tokens are not securities, where we don't have a legal relationship, where the token doesn't entitle you to anything, in and of itself, very often the token will have a dependency on a project that is not yet, for lack of a better term, sufficiently decentralized. There you have an asset with an economic relationship that's a little bit sort of different. What I'd call it is an externality. You have no right to cause somebody to do something, but you have expectations about what they'll do. In those cases, if that asset, if the project raised money in the original case by selling the asset, it's now widely traded, I think that the law should probably impose some disclosure obligations on the company that raised money. Probably the reason, and we all understand this in the crypto community, that you can raise money is because people like the idea of exiting through selling a product that trades and becomes liquid. No doubt about that. I think the responsibility associated with that benefit of being able to more easily raise funds is providing more transparency. So the Lotus Gillibrand Responsible Financial Innovation Act would impose disclosure obligations on people who start up projects, issue a token, the token becomes widely traded, but they're not yet sufficiently decentralized. So really, rather than sort of toggling on and off with the token is a security, it's not a security, how are you supposed to know? It's sort of ridiculous when you think about it. The right way to do it is to impose those disclosure obligations on the actual folks responsible, the people who raise money, and at least have them provide public disclosures. So I think that's one thing that we can do very practically and workably without, creating, all these other, adverse implications. The second is something we've long, I think, talked about, which is a federal oversight in some way or another for centralized digital asset marketplaces. The state money transmitter framework, is just not sufficient. I think we've seen that. What that framework looks like, there's a lot of debate. People will have different interests, but I think we can and should do better in creating an overall framework for centralized digital asset marketplaces. The third area, which is probably the most problematic and of course caught a lot of attention over the summer before things kind of went haywire, are just DEXs and what some people refer to as DeFi. I think DeFi is probably a little bit of a confusing term in my mind of what exactly is going on. In any event, I think that yet deserves other solutions, and that's a bit more complex, but things we can readily accomplish, say in the next 12 months, in the first year of the next Congress, are disclosure obligations for projects, tagging the project and the people who raise money, not because of the token, and having some federal oversight of centralized exchanges. I guess I'd be loath not to mention the third area, which is a kind of a corollary, and that's oversight of stablecoin issuers. I think very few people I've spoken to want some kind of government issued digital currency, a U.S. Digital currency directly. But the idea of a competitive marketplace where, whether it's Circle, whether it's Paxos, whether it's other new entrants, whether it's J.P. Morgan, having a coin, I think that will really help our wider economy in a lot of ways, but that also needs a framework, I think. So that's one other area I guess I would touch on.
Each one of those is super, super sensible, Louis. And I'm particularly, honestly, even stoked as an investor myself on the idea of specific disclosures that are calibrated for digital assets, because these things are so different. Like it is really, really night and day what the operations can look like and what's important for an on-chain entity versus an off-chain entity and the types of requirements that you need. So it's, I think disclosures, like you said, very low-hanging fruit, absolutely should be implemented super fast. Banking requirements around stablecoins, potentially things like that also could be, very interesting to explore. I think that each one of those examples is a really, really neat way that we could push the industry. I think, as we kind of come to the end here, Louis, one last kind of fun question, right? So I have a pretty strong tilt towards Web3 gaming, obviously. That's almost everything that I do. How does regulation, in your mind, kind of play into the Web3 gaming narrative? Does it help? Does it hurt? Where do those two interplays sit?
Yeah, I was definitely thinking a lot, and we do think a lot about Web3 gaming. From a regulatory point of view, I'm not sure I would treat it all that differently, but I just, my own thoughts, talking to a lot of builders as you do in the space, I feel like in Web3 gaming, we're sort of at the music, online music before the Apple iTunes store. Nobody's really figured out how to jiggle the key in the lock yet. People have, there's a there, but they just can't quite see it. I think what we're still at that point where Web3 gaming is too much about just replicating existing models, but and you could buy an NFT of that. Nobody cares, and it's been really rejected, I think, pretty clearly by the actual gaming community, who everyone should be responsive to. Those are our customers, those are the users, right? And it's rejected. I think we just have to be honest about that. I think that's because people haven't really been outside the box enough in terms of thinking about whole new models. It's really, Web3 is about community creativity, community engagement, and we see parts of that in the gaming world on user created content like maps and other things. And I think we need to find more ways to bring the user into the game creation and kind of evolvement, if I can use that term. And that's really what Web3 is about, and creating incentives for them to do that because they can monetize those efforts. I think we've done too many projects are just too much just old models being stuck on here, and I think we just need the Steve Jobs of online gaming. I think we'll get there for sure, but it's going to take a little effort.
No, and I particularly like the example you used there, Lewis, because it's a very easy one to imagine, is this idea of players creating maps, players creating game components, having some royalty or financialization attached to it potentially, but ownership right at the end of the day of the creation. Yeah. So no, very excited to see that, and happy to hear your outlook there on the regulatory space as well. So final question then, Lewis, right? So as a participant within the Web3 space in general, you obviously talk to a ton of builders, venture builders and investors. What is some, obviously not legal advice, not formal advice at all, but what is some advice that you would give to builders who are looking to set out in the space? Maybe things they want to avoid or things that they should pay attention to at the start.
Yeah. I mean, I hate to say this, and it's certainly not meant to be self-serving to me. You really should engage with counsel and find a good relationship, find a good working relationship of people you like and trust. There are a lot of pitfalls right now is the reality. A lot of mistakes have been made, and you don't want to make those same mistakes. You don't want to find yourself, I know there's a tendency in tech to move fast, break things. The consequences of that can and have been severe. I would say, really think carefully. I would say one other piece, more foundationally, tokens by themselves without a business model that supports them can be a very empty vessel. It's really just, unfortunately, a way of exiting without much model. Think about if you're a founder, how does your company or your business interact with the protocol you're creating? Are you going to be one of those map creators, for example? You create a platform where people could do things, and then how do you add value to that platform separately? That way, you're not reliant on, I'm just going to hold a lot of tokens, and when the number goes up, I'm going to sell them. Yes, that's a poor model, and it's really been, I think, discredited. So rather than that model, it's more whether you're doing a fair launch, which is a wonderful thing if you can do that. But even if you're not doing that, think about what is your actual ongoing stake without being the driver of the community, but being part of that community. One just last example I'd like to use here, imagine, you found baseball too kind of slow and static, but you like the strategy. Basketball's fast moving, but it's the last 3 minutes is the whole game. You create a new sport, right? You fuse them and you call it basketball, and people are running around hitting each other with bats and throwing large orange balls at each other, and it's really super exciting. That's the protocol, right? You've created a new set of rules. That's fine. You want to have a team that's going to play that game, engage, and make money. Your team may be successful or not successful. You may fold your team. The protocol lives on independently of you. How do you bring that kind of idea to the table? You're creating something that you're going to later engage with, but it's not wholly dependent on you. So that's kind of as a mental model, something to think about.
I think that's fantastic, Lewis. Just be value additive, right? Like yes. As a builder, consider, separate your governance and your operations functions and make sure that you are contributing, even outside of the venture. Lewis, this has been a ton of fun. Very, very insightful. Thanks a ton for your time today. And we'll be looking out for more fun reports from you guys over at DLX.
Thank you so much, Sam. Appreciate it.
All right. See you, Lewis.
Bye.